Can someone still be prosecuted under PMLA if they are acquitted in the main offense? Main offense means the offense registered by the police, which is the predicate offense. So the question is, if the predicate offense does not exist, can there be proceedings under PMLA? Let's hear exactly what the Supreme Court and the High Courts have said. Section 3 of PMLA defines money laundering. Now, to attract Section 3, the intent, the knowledge of the offense under Section 3 is important. If there is no knowledge, there is no money laundering. In Vijay Madan Lal Chaudhary, Supreme Court observed, if the person is finally discharged, acquitted of the scheduled offence, or the criminal case against him is quashed by the court of competent jurisdiction, there can be no offence of money laundering against him or anyone claiming such property being the property linked to stated scheduled offence through him. In Parwana Dibbur's case, the Supreme Court stated, in a given case, if the prosecution for scheduled offence ends in the acquittal of all accused or discharge of all accused, or the proceedings of the scheduled offence are quashed in its entirety, the scheduled offence will not exist and therefore no one can be prosecuted for the offence punishable under Section 3 PMLA. In Parvati Kollur's case, Supreme Court observed, High Court was not right in setting aside the discharge order despite the fact that the accused had been already acquitted in relation to the scheduled offence and the present appellant were not accused of any scheduled offence. Now the next case is important. In Nick Nish Retail Limited case, the Calcutta High Court observed that when there is no scheduled offence, there can be no proceedings under Prevention of Money Laundering Act, as the offence under PMLA cannot stand alone. The Enforcement Directorate moved an SLP before the Supreme Court of India with a diary number 24321 of 2023, and the Supreme Court reaffirmed that when there is no predicate offence, there can be no offence of money laundering against the accused. The Telangana High Court in Manturi Sashi Kumar's case and the Delhi High Court in Prakash Industries case also held the same principle. However, in Gagandeep Singh's case, the question whether proceeding under PMLA would survive upon acquittal or discharge of the accused in a scheduled offence is sub judice before the Honorable Supreme Court of India. But in light of the judgments discussed, it is clear that no predicate offence means no case under PMLA. That's the law as stated by the courts. How do you like the video? Do not forget to comment, stay connected, and don't forget to subscribe the channel.